deals in the matters of the French state and the Kingdom of Spain and the London Steamship Owners Mutual Insurance Association.
Good morning, Mr.
Good morning, my lord. As I said last night when we closed, I proposed to make submissions on injunctive relief. Ms. Hart will make submissions on Section 50. There is overlap between the two topics, in particular the question of what is meant by power and jurisdiction. And so I will endeavour to cover the bits of that issue which aren't Section 50 specific. So my plan of action, if you like, had been to make submissions on the wording of Section 48, which I'll take quite lightly, then to look at what's meant by power and jurisdiction in our submission, and then I'll address the club's specific arguments, not all of them, but the principal points which are made. Now, the state's case on this part of the appeal is really very straightforward. In our submission, there's no real ambiguity or any ambiguity in Section 48, subsection 5. In cases where there is no agreement between the parties as to the powers given to the arbitrator or the tribunal has the same power as the court to grant an injunction. Therefore, where the court can grant an injunction, so can the arbitrator. Where the court cannot grant one, neither can the arbitrator. And it really is as simple as that, because that is plainly what Section 48.5 says. That is also in keeping with what I shall say is the purpose of Section 48.5. The effects of Section 48.5, the natural consequence of the wording of that provision, is that in this case, by reason of Section 13, subsection 2, subsection A of the State Immunity Act 1978, the court does not have the power to grant an injunction against either state, because the State Immunity Act tells the court it shall not do that. Therefore, Section 13 removes the power which would otherwise be available to the court to grant an injunction under Section 37 of the Civil Courts Act, where it's just and equitable, or just and convenient, rather, to do so. And in our submission, the court's powers, and because the court's powers are curtailed, so automatically by operation of Section 48, subsection 5, the tribunals. And I would just say on that point, it's important to recognise, because of the case which is put by the club, that this is not a case of the State Immunity Act removing powers from an arbitrator, which an arbitrator would otherwise have. Section 48 is the source of the arbitrator's power, and it is the limit of the arbitrator's power. And it is simply as a consequence of that limit that the power to grant injunctive relief is not available in this case by reason of application of Section 13, combined with Section 48. And in terms of the purpose of why Section 48 should be framed in this way, we say it's pretty obviously because in a default powers case, as distinct from a case where the parties have agreed what powers the tribunal ought to have, for example in an arbitration clause, terms of reference, institutional rules, there will be a presumption that any relief granted by a tribunal should be capable of enforcement by the court pursuant to the Section 66 claim form procedure. And in my submission, that is particularly the case when one is looking at injunctive relief, which can only be enforced by contempt, and which therefore can only be enforced by the court. It is simply not within the powers of tribunals to enforce injunctions. If I could just ask the court to turn up Section 48.5, it's please at Authorities Bundle B, tab 9, page 101. With apologies if it's not, that's where I have it. And I realise the court will have probably looked at this and is obviously very familiar with this section in view of the questions that came out yesterday. So I'll take this quite quickly. I think it will help just to have it on screen as the background to the submissions in general. Section 48.1 addresses the position, obviously, where the parties have agreed on the powers available to the arbitrator, so where the arbitration clause, for example, incorporates institutional rules. That gives effect to the principle of party autonomy. Parties can agree to confer on arbitrators, tribunals, whatever powers they want. The court may not be able to enforce whatever the resulting award is, but that is a matter for the parties. And in response to the question raised by my Lord Justice Vosh yesterday, that is obviously in my submission what the DAC report is referring to. When it's saying there's no reason to limit the powers of the court, it's referring to Section 48.1. And also in my submission, if one were to have an arbitration agreement or terms of reference which conferred powers on a tribunal to grant an injunction against the state, all that was provided for in the institutional rules of reference, then the tribunal would have the power under section 48 to grant an injunction against the state. And that would also very likely satisfy the requirements in section 13 subsection 3 of the State Immunity Act for written consent. So the two would work in tandem. You have written consent for the purposes of section 48.1 to granting an injunction against the state. You'll have written consent for the purpose of section 13.3. So the two statutes match. But if one is looking at pure statutory construction in terms of what the drafters of the Act were trying to achieve by subsection 5, there is the obvious point which the court has, that there is a clear difference in language between subsection 2 and subsection 3, where the tribunal is granted broad blanket powers, and the provision in section 5 which ties those powers to the powers of the court. If Parliament had been intending to confer a class of powers on an arbitrator, as opposed to a specific power and tying that power to the power of the court, then it would have been extremely easy simply to either track the wording of section 37 of the Senior Courts Act in this provision, or it could simply have read, as the previous two subsections do, the tribunal has the power to order a party to do or refrain from doing anything, and not refer to the court at all. The reference to the court is obviously a conscious decision taken by the drafters of the provision. And if the drafters of the Act had intended to vest in the tribunal a class of power, which was not limited to the powers of the court, then why introduce reference to the court? It simply wouldn't have been necessary. And the only reason the court is referred to at all in my submission is to achieve parity and to synchronise the powers of the court with the tribunal in its default powers case. And so, in response to one of the club's principal arguments, that, and it was something that Sir Peter Gross found persuasive, that there's no policy reason why the Arbitration Act should restrict the powers of arbitrators to grant injunctions against states, because there's no parum parum issue. Firstly, we say it's irrelevant because of the plain wording of section 48.5. That's simply what it says, and that's the result it brings about. There's also good reason for the legislator to have done it, because awards feed through to courts for enforcement, and that is obviously what the issue which the drafters of the legislation had in mind when tying the powers of the tribunal to that of the court. Indeed, it was something that Sir Peter Gross recognised in his award, where he said that when talking about injunctive relief and awards, enforcement inevitably looms large. It does. I was going then, rather than saying anything else about the wording, to the question of the meaning of power, because, and jurisdiction, because a key issue on this aspect of the appeal is what is meant by the word power in section 48.5, and of course that the language of jurisdiction then feeds through into section 50 of the Senior Courts Act. But again, we say the position is straightforward. What is meant by power is simply, can the court do something? If the court can do something, even if it won't do something, then it has power. If the court cannot, it does not have the relevant power. And where, because the State Immunity Act, the court cannot grant an injunction against the state, the court has no power to grant that injunction. And we say neither does the tribunal. But in my submission, understanding power in this very simple way, the court being able to do something, is consistent with the authorities both on injunctive relief and on state immunity. And so therefore I was going to take the court fairly quickly to a couple of the key authorities which deal with this issue. And the first I was going to take the court to is A Company Limited and Republic of X, which my learned friend took the court to yesterday, but I just wanted to show the court a couple of the passages. It's the Authorities Bundle B, tab 21, and the first page of the report is at page 416 of the bundle. And if the operator could actually get up page 420, of the bundle, those would be the passages I rely on. As my learned friend said yesterday, this was a case for Mrs Justice Saville, and it's a case where the plaintiffs had obtained leave for service out of the jurisdiction and a Moreover injunction against State X, which then applied to set it aside by reason of Section 13(2)(a) and the Diplomatic Privileges Act. And the principal issue in the case was whether a contractual waiver of immunity was wide enough to encompass the grant of injunction, which it was, isn't relevant for present purposes, but the question arose as to how the court was to approach discharge of Moreover relief where the defendant had raised an issue of state immunity, i.e. was it to be decided on a final basis or on a good arguable case basis. And the relevant part of the report starts, it's page 420 of the bundle, at the final passage on the right-hand column. And I should say the passage I'm about to read, forgive me.
Which page?
420 of the electronic bundle, page 524 of the report.
Electronic 431, I think.
4420.
Yeah, you've got it. Your pages are not the same as ours. So,
forgive me. It's page 424.
Anyway, 524, bottom right.
Bottom right. There remains one final matter.
Yes.
Where it says that. Now, here is referring to the Section 1 immunity, general adjudicative immunity, but you need to look at this to see the context of the rest. He says there remains one final matter, which is how the court should deal with cases where Moreover injunctive relief is granted against the state, which then applies to discharge or vary the injunction on grounds relating to its sovereign rights, including its rights in respect to diplomatic immunity. It is clear that when a state seeks to rely on general immunity conferred by Section 1, go over the page please, of the State Immunity Act, the court must finally decide at the outset whether or not such immunity exists. Thus, when a state seeks to discharge a Moreover injunction on the grounds that it is immune from the jurisdiction of the courts of the United Kingdom, the court cannot allow the injunction to continue on the basis that the plaintiff has a good arguable case that immunity does not exist. For in truth, if immunity does exist, then the court simply has no power to continue the injunction. Now, I accept that's general adjudicative immunity under Section 1. However, moving on to the next paragraph, it becomes specific to Section 13. And he says, to my mind, the same reasoning applies when the court is asked to grant the relief or order the processes referred to in Section 13, subsection 2a and b of the Act, and the state or other entity claiming such privileges or immunities seeks to rely on those subsections to say that the court has no power to do what it is being asked to do. If those subsections do apply, then the court again has no jurisdiction to grant such relief or order such processes. And he goes on in the final 3 paragraphs of this report to draw the distinction between an immunity point which goes to the court's jurisdiction, which is relied upon by a party seeking discharge, and one which goes to an ordinary exercise of discretion. In this case, the example that Moreover relief won't be granted where the assets of the relevant party or the respondent won't be amenable to enforcement. That was a matter of discretion, it was not a matter of jurisdiction. But the key point from the authority is that Mr Justice Saville analysed Section 13 in terms of whether the court had the power to grant an injunction, which he considered came to the same thing as whether it had jurisdiction to grant an injunction. Jurisdiction and power simply mean the same thing in my submission. The next authority chronologically, and the court was taken to it yesterday, but I just have to explain it in a slightly different light, is Jagged and Sawyer in the context of Section 50 damages. If I could ask the operator please to go to, on the court, to tab 22 of the bundle, so next tab along, next case. In my pagination.
In way we've got it.
You've got it. Next one. I'm grateful. And the relevant. Let me see. Forgive me. Get the right page.
Can we just look at what Lord Bingham said? Lord Bingham was at 276 to 7.
My lord, yes. And my learned friend should around 278. the operator, you go to page 429. No, 28, please. Uh, 429? Bundle B.
It goes on, doesn't it?
It is quite lengthy. I didn't know if my Lord had a particular question. I mean,
I think the problem with it is that what Lord Justice Millett said is coloured by what Lord Bingham said.
Well, what Justice Millett says is then adopted by the House of Lords in one step, and it's also been adopted by the House of Lords, the Supreme Court, very recently.
Well, I expect we're going to look at that in a moment.
Yes.
Okay.
Well,
All right. Anyway, we can look at Lord Justice Millett at page 285 in the report.
My Lord, yes. My Lord was taken to it yesterday. It's page 284 of the report after H, page 437 of the bundle, please.
It's all uncontroversial.
And it was paragraph 4 and 5. I don't know if the operators get 4 and 5 on the screen. Where he says in 4, the power to award damages under Lord Keynes's Act arises whenever the court has jurisdiction to entertain an application for an injunction or specific performance. This question must be determined as of the date of the writ, which I raise simply brings the court's attention in light of some of the comments made yesterday in terms of when one looks at this question, assessing jurisdiction, and the submission that states consent in at any time and then sort of confer jurisdiction. Ms. Hart will come back to that. I just raise it now. And it says if the court would then have jurisdiction to grant an injunction, it has jurisdiction towards damages instead. And then when one goes on to read subparagraph 5, where he says there have been numerous cases where damages under Lord Keynes's Act were refused because at the date of the writ it was impossible to grant an injunction or specific performance. In my submission, what he's talking about in these two paragraphs or subparagraphs is jurisdiction in terms of power, could versus would, as opposed to some factual or physical impossibility of granting the relief, which has occurred in a number of the Section 50 cases. It's simply no longer to have an injunction restraining nuisance on land because the person no longer has the land in question. That's one form of impossibility. But the fact that Lord Millett was using various cases to illustrate the point does not detract from what he was saying. He was looking at it in terms of what the court could do, what it had power to do, and therefore what it had jurisdiction to do. So he equates power to jurisdiction, and power in terms of whether the court could do something or not
Is that really right? In those cases of impossibility, because I think Lavery, they may have just waited too long, for example, it's not the case that the court wouldn't have jurisdiction. It just wouldn't choose to grant an injunction or specific performance, for example, requiring houses to be pulled down. That's very different from saying there's no jurisdiction.
Well, that case is in terms of pulling the houses down. That's right. The court just won't exercise its discretion to do that. But where it's the case that, for example, the land has, for example, left the ownership of the party applying for the injunction, the court queried whether the court would have.
But I think the two cases referred to here, Lavery and Purcell and Surrey County Council, are more in my first category.
Yes, they probably are. But I suppose he was using it in a slightly wider sense, that wherever it is impossible for the court to do something, it does not.
I have to say I have some difficulty with that. I mean, it seems to me perfectly sensible to say if there's never at any possibility going to be any chance of an injunction or specific performance, then essentially Section 50 isn't engaged. That's what this appears to me to say by reference to the cases referred to. That's not quite the same as our case.
It's not quite the same as our case, where you've got a statutory bar. But in a way, these cases are, in fact, they're less extreme than our case, because it may not be a matter going to strict jurisdiction. He may say, well, just as a matter of a rule of law or a judge-made law, where an injunction simply isn't granted in these circumstances. So, for example, say where specific performance is impossible, because the contract simply cannot be performed anymore, I'm going to say that's an impossibility and not going to grant damages under Lord Keynes's Act. But in this case, where one is looking at a statutory bar saying you cannot do this thing, that's a very easy case to fit into Lord Millett's description, whether the court has power when it can do something, because it just can't. So if one likes them, perhaps some of the cases he is referring to are more on the margins, in terms of whether one is looking at jurisdiction, as one might say, in a strict sense, or a slightly wider, or taking a wider perspective on it. But in our case, it doesn't matter, because in my submission, I'll be saying you're looking at it truly in the strict sense, in terms of the court not having the power to grant injunctive relief, where there is a statute telling the court it does not have the power, or shall not grant an injunction. And in terms of Lord Millett's description of the position in Jagged, I don't think we do need to turn it up, but that's been relied upon by the Supreme Court in the United Utilities Water case in Manchester Ship Canal very recently. And the reference to that is paragraph 130 of the report. And why don't we just turn it up just in case? It's page, tab 58A of the bundle. It's the last authority in that section. Page 1561.45.
Which bit of it do you want?
It's paragraph 140, my lord. 130, rather. The top of the blue side lining. It's just that paragraph where Lord Millett's statement in Jagged, which I relied upon, and subsequently in one step.
Yes, I was actually rather interested in the last sentence of this paragraph, where Lord Reid and Lord Hodge say, insofar as the court is implicitly constrained by the scheme of the 1991 Act, that's the utilities legislation, from granting such an injunction, it has the power to award damages.
My lady, yes, because it's not expressly constrained. It has the power to do it. There's no statutory constraint. It's looking at the scheme of the Act. the whole point of this decision is you've got a statutory scheme.
May I make,
of course,
just make my point? He's assuming that the court may be constrained from granting an injunction by the scheme of the 1991 Act. Yet, he is saying it has the power to award damages in lieu. I realise this may go to
that's why
the point that,
exactly.
that Ms.
A
Hart's
bit I'm less
making
prepared
submissions
to deal with.
But I wanted to bring that point up. It seems to me to be relevant.
That needs to be dealt with. Yeah.
Thank you.
Can I just check with Ms Hart, because there may be a straightforward answer that I will understand. If I don't understand, Ms Hart will answer it in due course. The simple point which Ms Hart makes to me is that at this point they're talking about a constraint on the discretionary aspect of Section 50. They're not talking about a constraint on the power of the court to do something, and so it's on a different point. But Ms Hart will come back to that in a bit more detail, but that's the basic point, and I'm very grateful for that. Unless the court had any additional questions on this particular authority, and this is the only reason I was going to this authority, just to show the endorsement of Lord Millet and what was said in one step. The next authority I was going to address just briefly is Furey and LaRue, because the court's already been taken to it, and that's at tab 32 of the authorities bundle B, page 597. For the operator, please. And the court will probably be familiar with the authority, but it's a case which has now been affected in terms of its actual decision by convoy and broad idea. But this was a freezing order granted in favour of a liquidator of 2 South African companies on the basis of alleged asset stripping. But at the time the injunction was granted, the liquidator had not and did not intend to commence any substantive proceedings, claims against the defendant. So the defendant applied to set it aside on the basis that the court had no jurisdiction to make such an order in the absence of underlying proceedings or an undertaking to commence them forthwith. And the House of Lords decided that in those circumstances, i.e. no underlying substantive cause of action, there's no jurisdiction, or that you couldn't have an injunction. That's the bit that's been affected by the decision in convoy and broad idea subsequently. And the club has relied on this authority for the proposition that what is meant by jurisdiction is jurisdiction in the strict sense. That's what Lord Scott says in terms of personal service in Section 37.
Paragraph 25 says it all.
Well, my lord...
The first part of paragraph 25 in the quote from Lord Justice Pickford.
My lord, that's what I was going to take the court to. Because what Lord Justice Pickford says at 25 is that the only really correct sense of the expression that the court has no jurisdiction is that it has no power to deal with and decide the dispute as to the subject matter before it. And that really is the key proposition, and that is what the House of Lords, that was the sort of linchpin of their reasoning in this decision. Now, of course, in this decision they did say, or Lord Scott did say, I think 25, that jurisdiction in the strict sense is personal jurisdiction in terms of service, coupled with the general power and equity to injunct represented by Section 37 of the Senior Courts Act. However, that description was given in this case because that was all that was relevant in this case. Power and fury simply meant personal service together with Section 37 because there was no other limitation on the court's power in that case. There was no additional statutory restriction. And in my submission, in any event, if one is just looking at it as a matter of logic, it doesn't make sense to equate in an arbitration context power with personal service, which is how the court would take jurisdiction, because an arbitrator takes jurisdiction in a different manner from the arbitration clause. And so why, if you like, tie the power of the arbitrator to service in court proceedings, in service which probably won't happen in any event because there won't be court proceedings because this is all hypothetical. In my submission, it doesn't make sense. But in any event, the position is clarified when one comes on to the next authority, which is convoy and broad idea, because the Supreme Court makes, or the Privy Council rather, makes the position explicit. And that's at tab 53, please. It's bundle page 1331 for the operator, and I'm looking for paragraph 39 of the report. Actually, if we could go down to paragraph 57, which page 1335.
Sorry, paragraph.
57, my lord, page 1, on my bundle 1335. For the report itself, the internal report, it's page 415. This is obviously Lord Legate giving the opinion of the board. And at 57, the Privy Council endorses the statement of principle in Spry, 9th edition. The powers of courts with equitable jurisdiction to grant injunctions are, subject to any relevant statutory restrictions, unlimited. And he goes on, injunctions are granted only when to do so accords with equitable principles, for this restriction involves not a defect of powers, but an adoption of doctrines and practices that change in their application from time to time. Unfortunately, there have sometimes been made observations by judges that tend to confuse question of jurisdiction or of powers with questions of discretion and practice. The preferable analysis involves a recognition of the great width of equitable powers, an historical appraisal of the categories of injunction that have been established, and an acceptance that, pursuant to general equitable principles, injunctions may issue in new categories when this course appears appropriate. And he says at the end of the paragraph that the board would likewise endorse that as a sort of correct statement of the law. I could then ask the court to drop down to paragraph 78 on page 1341 of the bundle, please, operator. And it's really in the middle of that paragraph, which I'm referring to, where the blue sidelining is. As discussed earlier, there was and is no limit on the power of courts with equitable jurisdiction to grant injunctions, except where restrictions have been imposed by statute. So in my submission, that's really the end of the proposition that jurisdiction and power means, in the injunctive relief context, simply personal service in section 37. It is then subject to a further potential restriction in terms of statutory restrictions. And statutory restrictions operate to restrict the equitable powers of the courts to grant an injunction, and that is precisely, in my submission, what Section 13 of the State Immunity Act does. It restricts a power which would otherwise be available under Section 37. And because that power is not available to the court, Section 48, subsection 5 does not confer it in the first place on an arbitral tribunal. That was all I was going to say on the authorities. I was then just going to move on to address, I suppose, the principal points that I distilled from the club's argument, put in its skeleton argument, but also from Mr Thompson's submissions made yesterday afternoon. And the first, and probably the key point that I discerned, was the idea that Parliament has not provided for the prohibition which the judge found to exist. The essence of the argument is that the State Immunity Act does not apply to tribunals, the 1996 Act does not refer to immunity, and therefore there is no policy reason, i.e. parum parum, to apply the State Immunity Act to tribunals. And there's a further then piece in the argument which goes, therefore by section 48, Parliament has conferred on the arbitrators a class of powers, including the remedy to grant an injunction. But in my submission, that final proposition doesn't follow from the first two propositions. simply begs the question of what default powers Parliament has conferred on tribunals by reason of section 48.5, because section 48 is the source and it is the limit of a tribunal's power. And in my submission, when construing section 48, it's not necessary to try and generate some scheme between independent statutory provisions. The correct approach is to work out what section 48.5 says, or what 48 says, why it says it, and ascertain the circumstances in which the court does and does not have the relevant power. And in my submission, the Arbitration Act doesn't refer to state immunity because of itself, arbitration doesn't engage questions of state immunity by and large, and to the extent it does, it's generally catered for by the State Immunity Act. The State Immunity Act doesn't restrict tribunals from granting injunctions because it doesn't apply to arbitration and has no need to prevent arbitral tribunals from granting injunctions against states. But section 48 does tie the power of the tribunal to the power of the court, but that is not specific to state immunity. In any case, unrelated to immunity, where the court had no power to grant an injunction because there was a statutory restriction, section 48 would restrict the power of the tribunal to grant the injunction. Section 48, in my submission, is concerned with synchronising the powers of the court and the tribunal. It is not, if you like, an immunity-facing provision. Its purpose is not to import immunity into arbitration. It is to achieve parity between the powers of courts and tribunals. And section 48 in my submission also doesn't refer to immunity or the State Immunity Act, because the State Immunity Act is not necessarily going to be the only statutory provision or restriction on the powers of courts to grant injunctions. If the purpose is to synchronise the power of the court and the tribunal for the purpose of enforcement of an award, then it would not be a sensible or effective drafting technique to try and list out all of the statutory restrictions, which might apply to the court at any one time, but which might change over time. What section 48 does as a matter of drafting is to do it once and for all, and will capture all future changes to the extent that statutes are introduced to restrict the court's power under section 37. And there's also no doubt why, if you like, section 48.5 ties the power of a tribunal to the court to grant specific performance, because of the closeness, if you like, between orders for mandatory relief from specific performance and a mandatory injunction. They both require intervention and enforcement by the court in order to be effective and in a particular way. The club then alleges that there were three errors made by the judge. The first is said to be that he misunderstood what was meant by power. The second is that he put too much store in the potential utility of an injunction, and the third really is his dismissal of the CJEU example, the Gazprom example, relied upon by the club. In relation to the first of those, and these are the last points I will address the court on, it's said that the judge misunderstood what was meant by power in section 48, and that section 13 simply curtails the exercise of a power which otherwise exists via section 37 of the Senior Courts Act. And the club repeats its argument that section 48.5 confers on tribunals a class of powers. It doesn't refer to limitation which affect courts. But in my submission, it simply begs the question, and it's what I said at the beginning, that there's no question of section 13 removing from tribunals powers they would otherwise have, or placing restrictions on such powers. The power to injunct a state, absent the state giving written consent, is simply not conferred on tribunals. It's not a question of section 48.5 conferring a power and then removing it, or section 13 removing it. The power does not exist in the first place, which is why it's important to get away from the idea that section 13 is somehow removing something a tribunal would otherwise have. It's not removing anything. Tribunal does not have that power in a default powers case. And in that respect, the club doesn't have the right to the remedy in the first place, because this is a default powers case and the tribunal can only do what the court can do. So it's not a question of something being unjustly removed from the club. It is not a power available in the first place. Had the club included an arbitration clause in its policy, which incorporated institutional rules, which catered for injunctions against states, then the tribunal would have power under section 48 subsection 1. But that is not what has happened in this case. As to the second error said to have been made by the judge, that he put too much store in parity between courts and tribunals, and the lack of utility in tribunals granting injunctions. In my submission, it's fairly clear that a key function of the curial supervisory courts of the seat is to enforce an arbitral award. It is therefore reasonable to suppose that in a default powers case and in default of party agreement, the tribunal should only grant relief which the courts can enforce, including, of course, injunctive relief. And it's of some relevance that this court, in the resolute, in upholding Section 13, subsection 2A of the State Immunity Act, that courts can't grant injunctions against states, made the point that injunctions are particular forms of relief which are coercive, and without the coercive element, which is not available as against the state, they are intrinsically pointless. Actually, if we could just look at that, it's the resolute Court of Appeal decision, which is tab 56 of Authorities Bundle B. The first page of the report is at 1444. But the passage I'll be relying on is, if we start at paragraph 50 on page 1463. And if I could ask the court, please, to read paragraph 50 down to the end of 53, and then paragraph 55. I'd be grateful.
Down to where?
The bottom of paragraph 55, please, my lord. So in particular out of that, I rely on a proposition, in particular set out in paragraph 50, where the court says, no sensible injunction could be granted if the order were to make clear that there would be no criminal or financial consequences for non-compliance. That demonstrates why an anti-suit injunction is indeed coercive, unlike an order for damages. And at 53, where the court says that injunctions are inextricably connected with enforcement and with the threat of criminal and financial sanctions. The court is really saying that injunctions are only of use and effective if they're able to be enforced. If the court cannot enforce them, there isn't very much point in having an injunction, which rather in my submission explains the rationale for section 48, subsection 5 in a default case. In a case where the parties agree, it may be different. They may accept that they can have an injunction which is unenforceable. That's a matter for them. And I would just say that whilst the club criticises the judge for placing substantial weight on what he regarded as the perceived lack of utility of injunctive award, not capable of enforcement, that's not just a judge's view, it's this court's view of what the position is, and in my submission it's entirely correct. That brings me on to the final error said to be made by the judge, which I'm going to address, orally at least, and that's in relation to the West Tankers analogy, if you like, where they say, right, well, the CJU in West Tankers says you can't, EU member courts can't grant anti-suits injunctions against parties in other member states. That applies by reason of direct effects. That removes the power of the courts in this country to grant injunctions, and yet in Gazprom, the CJU has confirmed that injunctive relief is available from tribunals. I mean, in my submission, one is just comparing apples and pears with this example. I mean, firstly, as we've heard so many times in this appeal, arbitration is expressly carved out of the scope of the regulation. In my submission, it's really quite irrational to argue that a restriction imposed on courts by the regulation applies to arbitral tribunals, which are expressly exempted from the regulation. And the rule, if you like, in West Tankers, that courts of member states shall not, by reason of the principle of mutual respect, grant anti-suit injunctions against parties in other member states or in proceedings before their own courts. In my submission, the correct way to look at that is it's the same as a judge-made rule here. It's the equivalent to the Siskina. Judge-made constraints on the exercise of a power which otherwise exists. CJU instructing EU member state courts that they weren't to grant anti-suit injunctions in these circumstances. That did not remove, if you like, power in the strict sense under section 37 to grant those anti-suit injunctions. That is a qualitatively different matter from a domestic statute which instructs this court not to grant injunctions against the state. And of course, anti-suit injunctions and what the CJU was considering, the issue simply didn't arise as to whether the tribunals had the power in the first place to do this. In those cases, one was assuming that the tribunals do have the power under the arbitration agreement. It's not a question in those cases of any limit on the original powers of the tribunal to do something. So, in my submission, for all those reasons, the judge was right, and that the tribunal did not have the power to grant injunctive relief against France in this case, nor Spain, albeit I accept that's only important or relevant in relation to Spain when it comes to Section 50 damages. France, on the other hand, had an injunction granted against it by Dame Elizabeth Gloucester, so it is a matter of some consequence to France. So, unless I could assist the court further, I was going to hand over to Ms. Hart.
May it please the court. My submissions follow on directly because the position of the states is that the fact that the tribunal lacked the power to grant an injunction also meant that it lacked the power to grant Section 50 damages. By way of a roadmap for my submissions, firstly, I'll be taking a close look at the statutory language in both Section 50 of the Senior Courts Act and Section 13(2)(a) of the State Immunity Act. Secondly, I'll be dealing with the three key authorities on this issue, as well as the Alexandros T. And finally, I'll be responding to two of the club's additional arguments, which I won't have already addressed in my other submissions. First, to look at the statutory language, I'm conscious that the court is well familiar with it, but I wonder if we could please pull it up. It's at Authorities Bundle B, tab 5, page 42, which I believe would be page 53 of your Lordship's bundle. Of course, it says, where the Court of Appeal or the High Court has jurisdiction to entertain an application for an injunction or specific performance, it may award damages in addition to or in substitution for an injunction or specific performance. Our submission is that it is embedded in this text that it must be possible for the court to grant injunctive relief or specific performance. And just for shorthand, I'll just refer to injunctive relief, although of course we recognise specific performance is also included. If it's not possible for the court to do so for whatever reason, then the power in Section 50 does not arise. Critically, that's because of the reference in Section 50 to the word jurisdiction. Jurisdiction in our submission refers to whether a court has the basic power or competence to act, and it's distinguishable from a court's exercise of discretion. And this is really the nub of our submissions and the point that all of the authorities support. My learned friend Mr Hancock, says that the word jurisdiction has a more limited meaning, and he's put forward various arguments in that respect. First of all, he said that jurisdiction should be limited to jurisdiction in the strict sense. an argument that he's made with reference to Furi and broad idea. Now, Ms Delnott has already addressed that argument and said that that's not what jurisdiction means, or that strict sense that was put forward in Furi doesn't contain or circumscribe what jurisdiction means here, and specifically that jurisdiction can be constrained by statutory provisions. That was the point in broad idea. My learned friend then goes on to say that jurisdiction is somehow distinct from the question of whether the court has power to grant a remedy. He says that if you're getting to the stage of considering whether to grant an injunction against a state, it's already been established that the state is properly before the court for the purposes of exercising adjudicative jurisdiction. And he goes on to say that that is enough to establish jurisdiction for the purposes of section 50. But, my lord, my ladies, in my submission, that ignores that there are different aspects to a court's jurisdiction. There is adjudicative jurisdiction and there is enforcement jurisdiction. That distinction is very well established in the case law. I don't believe that we need to go to the well-known authority of Alcom and Columbia, but of course I can turn it up if it would assist the court. But at page 600 of that report, which is at page 409 of the bundle, tab 20, page 409, which I believe would be page 420 in the court's bundle, it explicitly says that section 13 deals with enforcement jurisdiction, which is a different type of jurisdiction to that that's dealt with in earlier provisions of the Act, which is adjudicative jurisdiction. And your lordship confirmed in the resolute that the exercise of a court's power to grant an injunction, and in that case specifically an anti-suit injunction, is an exercise, or would be an exercise, of the court's enforcement jurisdiction, because that remedy is fundamentally coercive. That was dealt with at paragraphs 44 to 51 of the resolute before this court, and Ms Delnott has already pulled up one of those part of that passage, so I won't pull it up again here. The key question then is, what sort of jurisdiction is section 50 referring to? Is it referring to whether the court is able to exercise adjudicative jurisdiction over the state? Or is it referring to whether the court is able to exercise enforcement jurisdiction by granting an injunction against the state? In my submission, it's very clearly referring to the latter of those. Section 50 is asking whether the court has enforcement jurisdiction to grant a particular remedy. And in order to exercise enforcement jurisdiction, it is necessary to have adjudicative jurisdiction, but that's not sufficient because enforcement jurisdiction is a separate question. My learned friend's final argument on the narrow meaning of the word jurisdiction is with reference to Jagged and Sawyer, and in particular Lord Justice Millett's distinction between what the court could have done and what it would have done, and I'll address that in just a moment, and in particular I'll address my lady's questions over whether that really was a jurisdictional question or one relating to discretion. The next aspect of the wording of section 50 that I'd like to take the court to is the words in addition to or in substitution for an injunction. These words likewise indicate that there must be some possibility that an injunction could be awarded. On the one hand, the section refers to damages being able to be awarded in addition to an injunction. Well, of course, you couldn't award damages in addition to an injunction if you couldn't award an injunction in the first place. More contentious words are, of course, in substitution for an injunction. In my submission, substitution connotes that damages are replacing the injunction. But if there's no power to award an injunction in the first place, then damages could not be awarded in substitution for injunctive relief. Instead, if damages were awarded in those circumstances, they would simply be awarded as a freestanding remedy for the underlying wrong, rather than a substitutive remedy for an injunction. And that idea of a freestanding remedy is not one that section 50 contemplates. My learned friend made the submission that the words in substitution for simply mean instead of, which means that, at least in some circumstances, it would be possible to award damages under Section 50, even if it were not possible to award an injunction. In my submission, that is incorrect. The word substitution has a specific meaning. It means that damages stand in the place of an injunction, and it is therefore premised on injunctive relief having been available in the first place.
That doesn't actually fit in with the scheme of Lord Cairns Act, or which this provision substitutes, because one of the established situations in which you could get damages in lieu were where it was too late to get an injunction. So you couldn't in any practical terms get an injunction because the horse had already bolted, but there was an infringement of your rights and therefore you could get damages in lieu. Now how does that stack up with what you just submitted?
My lady, that is one distinction that is in fact drawn in Jagged and Sawyer, and I'll get to it. Jagged and Sawyer was a case where the court decided that it could have granted an injunction, and yet it declined to do so because injunctive relief had been granted too late. So in those circumstances, it said we could still order the defendant to tear down the properties which it's constructed.
That was looking forwards. I'm putting to you a case where it's too late to grant an injunction. So you could have restricted somebody from doing something, but you didn't know about it at the time. By the time you've done it, it's too late.
Well, my lady, in fact, in my submission, in those circumstances, based on what is said in Jagged with reference to previous cases, if it genuinely is impossible to grant an injunction because it's too late, then the Section 50 power does not exist. The court is deprived of the power to grant Section 50 damages in those circumstances, and I'll take you to the passages in Jagged.
Why is it not could have granted an injunction? Why was Lord Justice Millett not saying they could have granted an injunction, but they wouldn't have granted an injunction, but the section is triggered? I mean, that's surely what he is saying.
Well, my lord, I think, if I've understood your question correctly, I think that is my submission, that there are circumstances where a court could have granted an injunction, despite, for example, it being sought late.
But they wouldn't
still have done it, but they wouldn't have. That is to be distinguished from a case where, whether because of lateness or any other reason, the court simply couldn't have.
Grant it.
And in those cases,
that deals with my lady's point, which is a would have not.
Exactly, it's a would have versus a could have not.
It's too late, so it wouldn't do it, but could have.
Exactly, versus too late and therefore could not do it, in which case Section 50 isn't available at all. And I've said this a number of times, but I will get to that. The final words that I want to take you to in Section 50 itself is the reference to the words jurisdiction to entertain an application for an injunction, as opposed to perhaps words that could have been used, such as whether there is jurisdiction to grant an injunction. In my submission, no special meaning should be attached to the words jurisdiction to entertain an application. The judge correctly held in my submission, this was at paragraph 365 of the judgment against Spain, that if a court could not grant an injunction, then it would equally say, well, I can't entertain an application for an injunction either. And in our submission, he was right about this. My learned friend says that this language, the language of jurisdiction to entertain an application, shows that this section was in fact directed towards jurisdiction in some other sense, such as whether there was personal jurisdiction over the defendant. But I've already addressed the court on why we submit that construction is incorrect. Stepping back from the language, there is also a principled point about what the purpose of Section 50
Well, entertain comes from Lord Cairns Act itself.
Correct, my lord. That is our submission, that it is a bit of an anachronism that's drawn over, and perhaps if the provision was being drafted afresh today, it wouldn't use that language. I'd like to briefly address the court on what the purpose of Section 50 is. My submission is that Section 50 was enacted to remedy the injustice that arises where a prima facie entitlement to an injunction exists, in the sense of the plaintiff or the claimant, could have obtained an injunction, but the court, in its discretion, decides not to award one. Section 50 is designed to compensate a claimant for that specific loss, the loss occasioned by the court's choice not to grant an injunction that it could have granted. If there is some reason why an injunction is not available, then the fact that it's not granted doesn't occasion the claimant any additional loss, additional to the loss occasioned by the underlying wrong. And that's true whether the reason the injunction is not available is because the property has already been disposed of or the shares already allotted, or because of state immunity making it impossible to grant the injunction. But Section 50 is linked to the jurisdiction to grant an injunction because that is the specific form of deprivation that Section 50 is designed to remedy. I'd like the court to hold that proposition specifically in mind because it is a proposition that's made good by the authorities, and I'll come back to it. It's in contrast to the submission that was made by my learned friend, who put forward a different argument regarding the rationale for Section 50. He says that Section 50 offers a remedy that is available even in circumstances when an injunction is not. In my submission, that asserted purpose is not consistent with the availability of injunctive relief being the jurisdictional threshold for Section 50, and is in any event not consistent with the case law, which I'll turn to in just a moment.
But if you're right, of course, it doesn't answer the question of whether equitable compensation is available.
Well, quite, my lord.
I mean,
yes,
I find this argument all sort of interesting but irrelevant, because ultimately we have to grapple with the question of whether equitable compensation should be or is available. And that is, as it seems to me at the moment anyway, an open question.
Yes, my lord, I agree that is an open question. And yet, your lordship has touched on an important point, which is that whether Section 50 damages are available or not doesn't speak to the broader question about whether monetary compensation is available. It may be that a claimant is able to procure common law damages. It may be that they're able to procure equitable compensation or some other form of monetary compensation. Section 50 creates a bespoke category of monetary compensation that compensates a claimant specifically for the fact that they were prima facie entitled to an injunction but didn't get one. So the fact that other monetary remedies remain available potentially in another case, and it would be for the claimant to establish in a given case that they do have that entitlement, helps to explain why Section 50 is circumscribed in the way that it is. And
well, that's certainly where it started.
Yes, my lord. That's correct in my submission.
I mean, whether it's got expanded over time is perhaps the point that's being made against you, but certainly where it started.
In my submission, the very recent authorities indicate that it hasn't changed over time, that it still has the limited nature that it did originally.
It still doesn't answer the $64,000 question, and you accept that?
I accept that, my lord, and you have Ms Dornett's submissions already on behalf of both states. Before I get to the authorities, I would like to take the court to Section 13(2)A of the State Immunity Act, which is at page 29 of the bundle, I believe, page 37 in the court's bundle. Of course, the court is well aware of this language, the key language being relief shall not be given against the state by way of an injunction. My lord, my ladies, you have the key point, which is that this is a mandatory provision prohibiting the grant of an injunction, and it doesn't go to any exercise of discretion. Ms Dilnott has already taken you to the case of A Company Limited and the Republic of X, which spoke about this as a provision which circumscribes the court's jurisdiction to grant an injunction. The cornerstone of my learned friend's submissions is that the judge and the states are wrong on the meaning or on the availability of Section 50 damages because Section 13(2)A doesn't itself address the availability of damages. My learned friend went so far as to say that the state's case is that as a matter of the proper interpretation of the State Immunity Act, the court can't grant equitable damages against a foreign state. That was his submission. With the greatest respect, that is...
Sorry, who said that?
My learned friend, Mr Hancock. He said yesterday that the question was the proper interpretation of the State Immunity Act and whether it limited the availability of Section 50 damages. Now, we agree, of course, that...
I think I said the interaction of the statutes.
My learned friend
I
is
didn't
informing
hear
me that either what he said or what he meant was that it was what he was addressing the proper interpretation of both statutes taken together. But whatever the exact argument was that he was making, my submission is that as a matter of proper interpretation of the two statutes taken together, the outcome is the one that the states are advocating for and that the judge found was correct. Of course, it is not our argument that Section 13(2)A circumscribes or even addresses the availability of equitable damages. Instead, the role that Section 13(2)A performs is to limit the court's jurisdiction to grant an injunction. And the consequence of that limitation of jurisdiction isn't found in Section 13, or indeed in the State Immunity Act. Instead, the consequence is the one that's prescribed in Section 50. And indeed, there's another consequence, which is prescribed in Section 48(5) of the Arbitration Act, which is that an arbitral tribunal also won't have the power. But the consequence under Section 50 is that equitable damages will not be available. Mr Hancock has made two submissions on why these statutes shouldn't be holistically interpreted in that way. The first thing that he says is that the court shouldn't stitch together different statutory provisions to produce that sort of cumulative outcome. He says Section 13 doesn't address equitable damages, and Section 50 doesn't address the position of foreign states. And so you shouldn't be able to combine the two to produce an outcome that is specific to foreign states and equitable damages, because neither of those provisions makes provision for that outcome on its own. Our response is that there is nothing surprising or even particularly unusual about producing an outcome by reading statutory provisions in different statutes cumulatively in that way. Here, what we're told by Section 50 is that if the court has a particular jurisdiction, it will follow from that jurisdiction that it can exercise a particular power. But Section 50 doesn't tell us whether the jurisdiction exists in the first place. To determine whether jurisdiction exists, it's necessary to look at other rules. And one such rule is contained in Section 13(2)A of the State Immunity Act. There's nothing surprising or repugnant or abhorrent about combining the provisions in that way, with one provision circumscribing jurisdiction and another provision telling us what the consequences of that circumscription is. Second, my learned friend says that the policy rationale for Section 13(2)A, that policy rationale being that coercive orders should not be made against a foreign state, doesn't apply to awards of equitable damages. He says monetary awards are made against states all the time with no difficulty. In my submission, that misunderstands the distinct purpose of Section 50. As I've already said, Section 50 creates a bespoke category of damages which may be granted to remedy the injustice of an injunction being withheld. It's correct that it is not a specific purpose of Section 50 to prevent coercive remedies being granted against a state. That purpose is the one that underpins Section 13(2). But Section 50 has its own logic and policy, which is about remedying that injustice of an injunction not being granted. And so it doesn't matter if the purpose underlying Section 13(2) doesn't itself carry across to Section 50, because there is a distinct purpose. My Lord, I'd like to move on to the second part of my submissions, which concerns the authorities which we say are relevant here. The first authority is Jagged and Sawyer, which obviously you've already been taken to, and I won't be simply repeating Ms Gilnott's submissions. I'll be drawing the court's attention to slightly different passages and also addressing the question that was raised by my lady Justice Falk. This is Authorities Bundle B, tab 22, page 422. Now, just to be clear again on the facts here, in this case, the defendants had built a breach on land in breach of had built a house on land in breach of a covenant. The court found that the action for an injunction had been brought too late, in that it would guide its discretion as to whether an injunction was the appropriate remedy, and it declined to order an injunction and instead granted Rotten Park damages. But this was not a case of too late in the sense of it was now impossible to grant the injunction. The court just found that it would be highly inconvenient to the defendant and wouldn't lead to a significant benefit to the claimant, and so the overall justice of the situation militated against granting an injunction and in favour of granting negotiating damages instead. One passage that I'd like to take the court to is at page 437 on the printed version, I believe page 481 of the court's bundle. No, no, I'm sorry, I meant 448 of the court's bundle.
Anyways, yes, that's right. Bingo.
First one.
I can't believe I've got it. This is simply the point that's made between A and B at subparagraph 1. The jurisdiction was originally conferred by Section 2 of the Chancery Amendment Act, commonly known as the Lord Cairns Act. It is now to be found in Section 50. This is a trite point, but one that does bear emphasis for reasons that I'll come back to, which is that there is not a freestanding right to equitable damages, which Section 50 somehow limits. Instead, the power to award Section 50 damages is contained in Section 50 itself, and so it's quite natural that Section 50 sets the outer limits of that right. And that's not the same as saying that Section 50 imposes some constraint on that right. It simply determines what the scope of that right is, but I'll come back to that point. The next point that I'd like to go to is over the at the bottom of that page is subparagraph 4, which is the paragraph you've already been shown, and over the page is subparagraph 5, which is the key passage that my learned friend Mr Hancock spent time on yesterday. It's also one that Ms Gilnott has already addressed this morning. As she explained, in the cases referred to there, it had become impossible to grant an injunction, because the shares had already been allotted or the properties had already been disposed of. And in my submission, it's quite clear from what Lord Justice Millett says here that he considered that that was a removal of the court's jurisdiction for the purposes of injunctive relief, and it followed that it was therefore also impossible to grant Section 50 damages. Now, my lady, you asked the question of whether this was in fact a case where there had been a removal of jurisdiction, or whether it was better characterised as the court exercising a discretion not to grant injunctions. In my submission, that question is answered at page 442 of the printed version, which I believe is 453 of your version, down underneath F. This is where the court deals with one of the cases that was referred to in that earlier paragraph. This is the Surrey County Council and Bredero Homes case. At G, it's explained that this case is not authority on the proper measure of damages under Lord Cairns' Act, since the plaintiff's claim was for damages at common law and not under the Act. Now, the reason that it was for common law damages and not under the Act is explained over the page, starting at the third line, where it says, examination of the facts stated in the head note reveals that the defendant had disposed of all the houses on the estate before the plaintiffs commenced proceedings, and that the purchasers were not joint parties. Any claim to damages under Lord Cairns' Act must have failed. At the date of the writ, the court could not have ordered the defendant to pull down the houses, since this was no longer something which was within its power to do. So, my lady, in my submission, that speaks to the power But that is made even clearer over the page again. So this is now, I believe, 455 of the court's bundle. There's a paragraph that starts just above F, both the Rutan Park and Brodero Homes cases. And at the just above H, it says, starting on the right-hand side of the line, the unavailability of the remedy of injunction at one and the same time deprives the court of jurisdiction to grant to award damages under the Act and removes the basis for awarding substantial damages at common law. Now, that point about common law is a separate point, but the point that I want to draw the court's attention to is that because it was impossible to grant the injunction, that removed the jurisdiction to award damages under the Act. So I hope that that addresses your ladyships.
What does impossible mean in that context?
In that particular context, what was being referred to was impossibility as a result of the property having been disposed of. But in my submission, the principle that Lord Justice Millett drew from those cases, which is that wherever it is impossible for the court to grant an injunction, that also deprives it of jurisdiction.
Yeah. And he said, test that at the date of the writ. Is it impossible, or are there circumstances in which an injunction could be granted?
Yes.
In the Surrey case, it was clearly never going to be a possibility.
Yes, my lady. Which is different to Jagged and Sawyer itself, where it was possible, but the court declined to do it.
Yeah, indeed.
In this authority, I would just like to
that's the point about substitution, really. I mean, the sort of traditional wisdom, and I'm going back to the good old Chancery days, is that it was all about substitution. There had to be the possibility of an injunction if there was, but it was decided not to grant it. In the old days, you couldn't get damages in lieu, and after Lord Cairns' Act, you could. And it doesn't really tell you anything more than that, I mean, which is why it's so strange to find it raised really at all in this context.
Yes, and that point about being granted in substitution for an injunction to remedy the injustice of an injunction not being granted where it could have been is highlighted in some further passages in Jagged and Sawyer, which I'd like to take your lordship and your ladyships to now.
I mean, the great expert on equity jurisdiction was Lord Justice Millett. So, he really did know his onions where that was concerned. So we're looking at other passages in his judgment.
We are indeed, my lord. Specifically, if you go back to the page we were already at, 438 of the printed bundle, which is 449 of the court's bundle.
449.
I believe. That's the page we were just at, which has subparagraph 5 at the top.
Yes.
Down the page at subparagraph 7, the court is addressing an argument or a dispute that had arisen about whether it was possible, when damages are awarded in lieu, is it possible to come back for a further grant of damages? Could damages sort of be topped up periodically? Now, the precise substance of that dispute is not relevant in here, but what is relevant is what Lord Justice Millett says 3 lines from the bottom, where he says, it is in my view fallacious, that argument that you can come back for top-up awards of damages is fallacious, because it is not the award of damages which has the practical effect of licensing the defendant to commit the wrong, but the refusal of injunctive relief. Continuing over the page, thereafter the defendant may have no right to act in the manner complained of, but he cannot be prevented from doing so. The court can, in my judgment, properly award damages once and for all in respect of future wrongs, because it awards them in substitution for an injunction, and to compensate for those future wrongs which an injunction would have prevented. So that makes the exact point that your lordship was just touching on, which is that this is a jurisdiction to grant damages for the fact that an injunction wasn't granted.
Yeah.
Further down the page at next to F, in the second line of that paragraph, what does need to be stressed, however, is that the consequences to which the plaintiff refers do not, those consequences being essentially the
Sorry, where are you? F.
sorry, H. If I said F, I meant
yeah.
H.
Yeah.
Here he's dealing with an argument that the plaintiffs were saying, well, it's unfair that now the defendants are able to just engage in a breach of covenant in perpetuity. What he's saying is, what does need to be stressed, however, is that the consequences to which the plaintiff refers do not result from the judge's exercise of the statutory jurisdiction to award damages instead of an injunction, but from his refusal to grant an injunction. Lord Cairns' Act did not worsen the plaintiff's position, but improved it. What he's saying there is that Lord Cairns' Act made it possible for a plaintiff to be compensated for the fact that the court didn't grant an injunction. That's the injustice that's being addressed. One final passage, which is on this same page, and this is something that featured in my learned friend's skeleton argument. It's a passage starting just above F on that page. It says, when the plaintiff claims an injunction and the defendant asks the court to award damages instead, the proper approach for the court to adopt cannot be in doubt. Clearly, the plaintiff must first establish a case for equitable relief, not only by proving his legal right and an actual threatened infringement by the defendant, but also by overcoming all equitable equitable defences, which he lists. If he succeeds in doing this, he is prima facie entitled to an injunction. The court may nevertheless, in its discretion, withhold injunctive relief and award damages instead. Now, in this passage, the court referred to the need for a claimant to overcome equitable defences, and this is what the club seized on in its skeleton argument. What the court didn't mention was the need to overcome any other jurisdictional barriers, including those which may be imposed by statute. But in my submission, it's implicit in what Lord Justice Millett said here that his statement also encompassed any statutory bases on which jurisdiction to grant an injunction may be lacking. That's implicit because if it wasn't implicit, then the following sentences wouldn't follow. It wouldn't be the case that the claimant is prima facie entitled to an injunction. And even more, it would not be the court withholding in its discretion in injunctive relief. So in my submission, even though this paragraph only refers to equitable defences, it must also encompass statutory bars or statutory reasons why jurisdiction does not exist. That takes me to the second authority that I'd like to deal with, which is the One-Step and Morris-Garner case. This is at tab 44, page 870 in the printed version, I believe 881 in the court's version. Here the claimant was a company providing supported living for vulnerable children and adults, and a former director and former manager established a business which competed in breach of restrictive covenants. The judge had allowed the claimants to elect to receive negotiating damages, or Roten Park damages, rather than the ordinary compensatory damages reflecting the losses they had suffered, and the Supreme Court found that this had been an error. Of relevance to this case is what Lord Reid had to say on page 885, which I believe is 896 of the court's version.
He was the majority, was he? Because I think Lord Walker disagreed with him.
There was certainly no disagreement on the points that I'm about to make. And yes, my Lord Walker was not in this case.
Oh.
There were, there is in fact a passage from a judgment of Lord Walker that I'm going to address.
That's what he disagreed with.
Exactly.
Yep.
He disagreed with one particular aspect of Lord Walker's judgment, but not on the point that I'll be addressing.
No, okay.
I will say that Lord Sumption and Lord Carnmouth gave their own judgments in this case as well, but that's not relevant to the points that I'm making. They certainly don't undermine the points that I'm going to be taking the court to. So at the page which I just had up, 896 of the court's bundle, at the bottom is where Lord Reid quotes from the judgment of Lord Walker. And in particular, I'd like to draw attention to subparagraph 3.
Sorry, 896 in the paper.
No, 885 in the paper, 896 for the court. Is there a subparagraph 3 at the bottom? Sorry, 885. Sorry. Apologise if I've got this all muddled up. It's page 885.
I think we've got it.
It's not you that gets muddled up, it's the fact that we've wasted probably hours of the court's time by having the wrong numbering. But I obviously won't complain about it. But in the 7-day case, it adds up to quite a bit. Certainly not your fault, Miss Hart.
I am grateful, my
Paragraph
lord.
3. This judgment will abjure the use of the term Rutum Park. It was pronounced Rutum.
Root. This is a debate that I had with my leader, and I should have obviously paid closer attention. In fact, I'm looking at paragraph 4 of the judgment, subparagraph 3 within that, which is drawn from Lord Walker's judgment, where Lord Walker said damages under Lord Cairns Act are intended to provide compensation for the court's decision not to grant equitable relief in the form of an order for specific performance or an injunction. Same point.
Sorry, where are you?
So it's paragraph 4 of Lord Reid.
Damages are intended to provide compensation for the court's decision
right.
not to grant equitable relief.
Yes.
Yeah. Where the jurisdiction is entertained, yes.
And then my learned friend has asked me to read subsection 5. Although damages under Lord Cairns Act are awarded in lieu of an injunction, it is not necessary that an injunction should actually have been claimed in the proceedings, or that there should have been any prospect on the facts of it being granted. That's a point that's also covered in Jagged and Sawyer. The point is simply that if there was jurisdiction to grant an injunction, you don't actually have to seek one in order for damages
Well, Lord
to be
Reid doubts this later on, doesn't he? This subparagraph.
I believe that's right,
Yes.
my lady. I'd have to confirm because it's not the
But
point.
it's later on in this judgment.
Exactly,
isn't it?
but it's a separate point about whether an injunction does have to be sought separately, but that doesn't go to the question of whether an injunction would be within the court's jurisdiction to grant.
Yeah, that's what he doubts, yeah.
I'm grateful, my lord. If we could please go to page 897 in the reported version, which is page 908 in the court's version, paragraph 44 at the top of that page.
Yeah.
Damages awarded in substitution for an injunction are, as one might expect, a monetary substitute for an injunction. As Viscount Finlay stated in Leeds Industrial, the power to give damages in lieu of an injunction must in all reason import the power to give an equivalent for what is lost by the refusal of the injunction. Where it is likely that the refusal of an injunction will result in the claimant sustaining loss and damage as a consequence of the tort, breach of contract or other wrongful act which the court has declined to prevent, the damages should provide compensation for that loss and damage. Once again, putting the same point in a different way, which is that the purpose of section 50 is to compensate for an injunction being withheld. The same point is made at paragraph 62 of the same judgment. Mr Hancock has helpfully told me that paragraph 45 is where he deals with that other point. So down to page 901 of the printed version, 912 of the courts, paragraph 62. The awards in Rutum Park and others were made in the exercise of unique statutory jurisdiction, the award of damages in lieu of an injunction. The purpose of the awards was to provide the claimant with an appropriate monetary substitute for an injunction in the circumstances of the particular case. Over the page at paragraph 63, the measure of damages reflected the fact that the refusal of an injunction had the effect of depriving the claimant of an asset which had economic value, making the same point yet again.
Sorry, not quite sure where you were. Which
That last
paragraph?
bit that I read was that paragraph
63,
63.
sorry.
So the effect of depriving the claimant of an asset which had economic value, but it was the refusal of the injunction that is being compensated for. Could I also please show the court paragraph 95.3 of the judgment, which is at page 910 of the printed version, or 921 of the court's version. Damages can be awarded under Lord Cairns Act in substitution for specific performance or an injunction where the court had jurisdiction to entertain an application for such relief at the time when the proceedings were commenced. Such damages are a monetary substitute for what is lost by the withholding of such relief. Again, confirming that what we're talking about when we come to Section 50 damages is the withholding of relief, which is necessarily a discretionary, and that is what is being compensated for. If the court couldn't have granted an injunction anyway, then there's no loss to be compensated for under Section 50. The third authority is the Manchester Ship Canal Authority, tab 58A, page 1561.1, or I believe 1573 for the court, 1573. In fact, it might be convenient just to go to 1561.44, which is 1616 for the court.
1616.
For the court, yes.
Yeah.
Paragraph 128. Now, Ms Dilmot took you to a paragraph over the page which talks about whether the court could have granted an injunction or whether it was implicitly constrained from doing so. And the ladyship asked, well, was that a case where it was simply impossible? If they were implicitly constrained, is that almost equivalent to what's happening with Section 13? I'm going to take you to the paragraphs that show that this was a different situation. So starting the page before, at paragraph 128, it says, against that background being the fact that the 1991 Act, the court has already held, did not oust common law causes of action, we accept that the scheme of the 1991 Act, including this enforcement mechanism, might be disrupted if the court were to grant injunctions which require the sewerage undertaker to spend large sums to create new infrastructure as a remedy for interferences with private property rights. And the court goes on to explain more about why that disruption may occur. At paragraph 129, it goes on to say, nonetheless, in the context of the statutory provisions which we have discussed, this potential incompatibility does not provide a basis for the exclusion of the causes of action of common law which those provisions preserve. The incompatibility, and this is the key bit, the incompatibility may militate against the court in the exercise of its discretion, granting injunctions which require the upgrading of the sewerage system, but it does not follow from a court's conclusion that it should not grant an injunction that a remedy in damages is also excluded. So that sets up what is coming in paragraph 130, which is that this is a case of discretionary, a discretion not to grant an injunction. And that provides the context for what Ms Dilmot has already shown the court about halfway down the paragraph, just after the reference to JAGE. The court says, so this is just above C, the power to award damages is not curtailed when a court exercising its discretion does not grant an injunction. That's in contrast to the next sentence. So long as the court has jurisdiction to grant an injunction, it may award such damages under Section 50. So here the court is setting up the distinction between an exercise of discretion and a lack of jurisdiction. And the paragraph goes on to talk about the fact that if even when a court is implicitly constrained in how it exercises its discretion, and that's a reference back to the point about incompatibility with the statutory scheme, that still leaves it with the power to award damages. But the court will have my point, which is that Section 13.2a is categorically different from that implicit constraint. Section 13.2a is an express prohibition of a very different character. Now, my learned friend did point the court to those paragraphs, but at the start of his submissions, he wanted to use this case for quite a different proposition, which was about statutory ouster. He said that a statutory right a statute could only oust a cause of action by express words or necessary implication. The first point to make is that the club has never before framed its argument on section 13.2a in terms of this statutory ouster argument. Obviously, this authority is a new one, but the principles underpinning it in relation to statutory ouster are plainly not. And I'd like to lay down a marker that we don't consider that it's open to the club to advance this argument now. But in any event, we don't want to get too exercised about that point because we consider the point to be a very weak one. Your Lordship said that the context in which those principles were enunciated in the Manchester shipping case were a long way from our case, and in my submission, that is correct. Mr Hancock framed his submission in terms of whether section 13.2a ousts the right to equitable damages. We've never said that it does. Section 13 only deals with injunctive relief and specific performance and other equitable remedies. It doesn't deal with the availability of damages. Whether equitable damages are available or not is instead governed by section 50. This is a point that I've already made. Section 13.2a deals with jurisdiction, section 50 deals with the consequences of whether jurisdiction exists. In setting that jurisdictional threshold, section 50 also does not oust any right. Section 50 is the source of that right, and in providing for that right, it sets the outer limits of the right, or the scope of the right, but those outer limits are not a constraint on the right. They're not an extraneous limitation. Instead, they are simply part of the right. Unless I can assist the court further there, I'd like to move to the final authority, which was one the club took us to yesterday, the Alexandros T. I'll deal with this authority very quickly. The relevant passages which you were shown yesterday are at page 773 or 784 of the court's bundle. In this section of the judgment, the court is considering whether certain third parties to a settlement agreement, called the HD parties, could seek certain relief on the basis of the settlement agreement to which they weren't parties. Importantly, in the final sentence of paragraph 88, Mr Justice Flow held that those parties could sue under the 1999 Act, which is a reference to the Contracts, Rights of Third Parties Act of that year. He goes on to say in the first sentence of paragraph 89 that it's therefore not necessary to consider the fallback position. And that fallback position included an argument about equitable damages. So what the court goes on to say in paragraph 89 is obiter comments by a first instance judge.
Well, a fairly distinguished first instance judge.
Yes, I take the point, my lord, of course. And yet there are other, and yet the point is that it is still obiter comments. And in
It's
fact,
obiter.
what is said at paragraph 89, well, one such argument that was raised by counsel is raised starting 5 lines down. They said the HD parties would be entitled to enforce that promise by way of the equitable remedy of injunction, were it not for the principles established by the European Court of Justice in Turner and Grobet and West Tankers that such an injunction would be an illegitimate interference with the powers of the Greek court to determine its own jurisdiction. Counsel argued that those parties could instead seek damages in lieu, and the judge said that he would have been inclined to agree. However, Ms Dilmont has already made the submission that this judge-made rule, even though it emanated from the Court of Justice, is still a judge-made rule that fundamentally doesn't go to the jurisdiction of the court in the way that a statutory prohibition on the grant of injunctive relief does. And in any event...
But if that's wrong, he's wrong, you say.
I'm sorry, my lord.
If that is wrong, he's wrong, you say.
Well, yes, quite, my lord. And in any event, paragraph 89 is entirely unreasoned, which goes to my lord's point that, yes, if he's wrong about that, then it it does not appear that he took account of the jurisdictional arguments that would have barred the availability of Section 50 damages.
Even Homer can nod. Yes.
My Lord, that brings me to the final part of my submissions, which is to address two further submissions which are made by the club that I haven't already addressed in my other submissions. The first of those submissions is that the fact that a state may consent to injunctive relief shows that Section 13(2)(a) does not deprive the court of jurisdiction. The club's argument is that because the state can consent, that means that the court must have some form of latent or underlying jurisdiction, and that Section 13(2)(a) merely operates as some sort of bar to the exercise of that jurisdiction, but is not itself jurisdictional. It makes two further points. Mr Hancock made two further points, I'm not sure if he made these yesterday or if they were only in his skeleton argument, but in any event, the club has said it would be wrong in principle to say that by submitting to the court's jurisdiction to grant, or by consenting to an injunction, the state itself could vest the court with jurisdiction. They say in their skeleton argument that that is contrary to principle. And they've also made the point that Section 13(2)(a) can't be treated as jurisdictional because the state could consent midway through proceedings. The states submit as follows. First, jurisdiction, very clearly on the authorities which I've already taken the court to, simply refers to whether a court can or cannot do a particular thing. Where it can't, there is no jurisdiction. Now, Sections 13(2)(a) and 13(3) clearly need to be construed together. The result of those two provisions together is that a court shall not grant an injunction against a state unless the state consents. Absent consent, the court can't do so. So consent is a condition precedent to the exercise of jurisdiction. The club says that the state should not be able to vest the court with jurisdiction, that this is somehow contrary to principle. I have two responses to that. The first is that there is nothing particularly unusual or abhorrent about a defendant's submission to jurisdiction being the foundation for the court's jurisdiction. Stepping outside of the context of state immunity, in a case that could be said to involve ordinary parties, if there is no jurisdictional basis for the case to be before the English courts at the outset, i.e. when the claim is commenced, jurisdiction can nonetheless arise if the defendant submits. So in that case, it is the defendant's submission which is the foundation for jurisdiction, and there's nothing wrong with that in principle. But, and this is my second point, in the context of Section 13, that is not even what is happening. Read together, Sections 13(2)(a) and 13(3) say that a court can't grant injunctions unless the state consents. So again, consent is a condition precedent. If the state consents, that is not the state creating the court's jurisdiction. What creates the court's jurisdiction is the statute, which says that if a state consents, then jurisdiction exists. The state's consent is merely the factual predicate or the condition precedent, the fulfillment of the condition precedent for the existence of jurisdiction in accordance with the statute. As to the point that consent could arise partway through proceedings, we have a few responses. The first is that that is simply the consequence of the way that the State Immunity Act is drafted. There is no jurisdiction unless and until the state consents to the grant of an injunction. It's simply the same point that it's a condition precedent. The second point is that where submission is the foundation for jurisdiction, whether that's in a so-called ordinary case, whether it's submission by a state to the court's adjudicative jurisdiction, or whether it's submission by a court to the court's enforcement jurisdiction to grant an injunction, jurisdiction will always be lacking at the outset of the case, i.e. when the writ is issued, but it's generated as a result of the defendant's act after the action has started. But the third point is really just stepping back and making a sort of pragmatic or practical point. It seems that it would be very unlikely in practice that if a court at the outset of proceedings was immune from injunctive relief, that it would consent to injunctive relief partway through proceedings. although this can't be ruled out, it does seem like quite a remote possibility, and it would be peculiar if this remote possibility was what drove the analysis of whether the power was jurisdictional, or Section 13.2a is jurisdictional or not. The second and final point that the club made is that Section 50 must be read down under Section 3 of the Human Rights Act to be compatible with Article 6 of the European Convention on Human Rights. This is a point that my learned friend said that he would take lightly. It's only developed in a single paragraph in my learned friend's skeleton argument, and in my submission, the club had good reason for not pursuing it in a more full-throated way. If we get to this stage in the club's argument, then the court must have already accepted the state's argument that in Section 50, Parliament created a monetary remedy that was tied to the court's ability to grant an injunction. And that leads to two reasons why my learned friend's submission must be rejected. The first is that his argument misunderstands the role of Article 6. It is well established that Article 6 is not concerned with substantive rights or substantive obligations or remedies under domestic law. Instead, it is solely concerned with ensuring access to a court so that a litigant can enforce rights and remedies that already exist. So this case is different to the Resolute. In that case, there was an underlying right to seek an injunction, and what Section 13.2a did was pose a barrier to that right by saying that the court had no jurisdiction to grant an injunction. The club's argument is that on the state's interpretation and the judge's interpretation of Section 50, Section 50 confers immunity on a state from an award of equitable damages. But that, in my submission, is incorrect. Section 50 itself creates the power, that's the line that I showed you in jagged earlier, to grant a remedy. But Section 50 also sets the outer limits of that remedy. So the outer limits are that the court must have jurisdiction to grant specific performance or an injunction. That outer limit is not some form of constraint or a conferral of immunity on states. That is simply the scope of the right. By asking the court to interpret Section 50 in a way that allows equitable damages to be granted where the court does not have power to grant an injunction or specific performance, that is not removing some barrier to the exercise of the right in Section 50. It is enlarging the right in Section 50 itself. It is making the right wider than the right which Parliament created. It is using Article 6 to change the substantive law. That is impermissible, and that is a complete answer to the club's argument on reading down. If the court needed a second reason, it would be this. The club's request would require the court to do more than is permissible when using the reading down power in Section 3 of the Human Rights Act. The club hasn't cited any authorities on the power to read down, but the general point of those authorities is well known, and a recent recapitulation of them is in your Lordship's judgment in the Resolute. That's at paragraph 58. I don't think we need to take the court there, but it is at 141475 of your bundle if you want to have a look. Reading down cannot be used to controvert the underlying thrust of the legislation or to go against the grain of the legislation. Now, once again, if we get to this argument of the clubs regarding reading down, it is because the court has already accepted that Parliament intended to tie the remedy of equitable damages to situations where an injunction could be granted, rather than to provide for a freestanding remedy that could be granted even where an injunction could not. What the club would have the court do, however, is ignore that underlying fundamental intention of Parliament and interpret Section 50 as creating a monetary remedy that is available even though an injunction is not. In my submission, that goes against the thrust or against the grain of the legislation, and for that reason is not a valid use of the court's reading down power. My lord, my ladies, unless I can assist the court further, that concludes my submission.
Very helpful submissions, Ms. Hart, thank you.
May I respond? respectfully, on behalf of Spain, adopt the submissions that have been made by my learned friends.
You may. Well, I think we're a bit ahead, are we, Mr. Hancock?
Yeah, my lord, yes.
That's wonderful.
I'm going to try and stay ahead. So just a few points in relation to section 50, which is obviously what I'm going to be dealing with. And the starting point in my submission is that the question for your lordships is indeed, as I indicated, one of the interaction between Lord Cairns Act and the State Immunity Act. The proposition that is put by the states is there is no power to grant an injunction, ergo there is no power to grant damages in addition to an injunction or in place of an injunction, which are the two alternatives for which Lord Cairns Act provides. And so essentially the burden of their song is that everything flows from the ability to grant an injunction, that even if the considerations which prompt the Parliament to say that you can't grant an injunction have nothing to do with the alternative remedies in Lord Cairns' Act, nevertheless, the court should read Lord Cairns' Act down so that those alternative remedies are not available because an injunction is not available. And the question therefore becomes, well, why should that be? Well, Learned Friend's answer is to say, because if you look at the wording of the Lord Cairns Act, then the important word she says is jurisdiction to entertain an application. And so what is said is, if there isn't jurisdiction to entertain an application, therefore there isn't jurisdiction to entertain applications for the alternative relief, which you can get in addition to or in place of the injunction which the statute has prohibited from you from getting. I would submit that's a non sequitur. That is an overly semantic reading of the words. When one actually asks why Lord Cairns' Act was passed, it was to grant the right to damages, firstly, for cases where there were damages which had been suffered independently of an injunction, and secondly, where damages would be suffered because of the failure to grant an injunction. And if we could go back once again to Jagged and Sawyer, but with apologies not to Lord Justice Millett's judgment, but to Lord Bingham's judgment in Jagged and Sawyer, that is to be found at tab 22. The report begins at page 422. The portion that I would like to refer the court to begins at page 429 in the printed bundles. In the electronic bundles, it may well therefore be that it's page 440 and following. Internally within the report, it's page 276. Lord Bingham set out at letter D and following an account of the history behind Lord Cairns' Act, and as you'll see, that was based out on, but he acknowledged his debt to an article by Professor Jolovitz in relation to Lord Cairns' Act in the Cambridge Law Journal. And he says, historically, the remedy given by courts of common law was damages. These afforded retrospective compensation for past wrongs. If the wrongs were repeated or continued, a fresh cause of action was needed. Courts of equity, in contrast, were able to give prospective relief by way of injunction. or specific performance. A mandatory injunction would require the defendant to observe a legal obligation or undo the effects of a past breach of legal obligation. A negative injunction would restrain a defendant from committing breaches of legal obligation in future, but these courts could not award damages. This anomaly was mitigated by the Common Law Procedure Act 1854, which gave courts of common law a limited power to award equitable relief as well as damages. It was further mitigated by the Chancery Amendment Act 1858, Lord Cairns's Act, which gave the Court of Chancery the power to award damages. Section 2 of Lord Cairns's Act provided, and he then sets out the wording of the section, and he goes on to say, this enabled the Chancery Court, on appropriate facts, to award damages for unlawful conduct in the past, as well as an injunction to restrain unlawful conduct in the future. It also enabled the Chancery Court to award damages instead of granting an injunction to restrain unlawful conduct in the future. So pausing there, then that accounts for the wording of the statute in addition to, that's the past, in substitution for, that's the future. So the cases that you've been shown, as to which I don't think there's really any dispute between the parties, which relate to the measure of loss for not being given an injunction, which Miss Hart has shown you, that's, if you like, the second part of the equation, the grant of damages to compensate you for the fact that you're not getting the injunction. In relation to the first part of the equation, the past, that actually is simply the grant of damages to compensate you for the loss that you have already suffered by reason of the relevant breach. Just by way of a trailer, if we look at the facts of our current case, then there would be no question but that there has been a breach in obtaining the relevant judgment, etc., and that there will be a breach in getting enforcement of that judgment. Injunctive relief would prevent the future breach by way of enforcement. Compensation for the past would compensate for example, the costs that have been incurred by reason of the continuation of the Spanish proceedings. So far, so good. No problem with the rationale under Lord Cairns's Act for the grant of compensation in respect of a case like the current one. Then the problem that arises is because of the fact that the State Immunity Act then comes in and has to be read together with Lord Cairns's Act, and this is why I say it's a question of the interaction between the statutes, because the logic of the states, as I think was very fairly accepted, was you put the two together. Stage one is you can't get an injunction. Stage two is you can only get compensation if you can get an injunction. Stage three is therefore you can't get compensation. And we would submit with great respect, that's a bridge too far. For all the reasons I gave actually in opening, there's no good policy reason for suggesting that that should be the case. There's no good reason as a matter of legal history for suggesting that that should be the case. There's every good reason, as you've just seen from Lord Bingham's judgment, for saying that that shouldn't be the case. And then going back to the Manchester Ship Canal case, then, as my Lady Justice Falk pointed out, then there actually, what the Supreme Court decided is that it may be the case that the grant of an injunction would be inappropriate. In that case, it would be inappropriate because of the fact that it would cost far too much to perform the works that would be necessary in order to put right, if you like, the sewerage system.
Well, it wasn't simply that. It counter the statutory scheme.
Indeed.
To understand it in terms of what was expected by way of capital expenditure.
Indeed. And so, in a sense, that's why it wasn't a discretionary decision on the part of the Supreme Court. What they were saying is that where Parliament has said, thou shalt not give remedy X by way of the statutory scheme in the sewage legislation, that means you shall not give remedy X, but that doesn't mean thou shalt not give remedies Y and Z, which under Lord Keynes's Act are the alternatives to giving remedy X. And as my lord, my ladies saw, then the Supreme Court specifically referred to Section 50 and Lord Keynes's Act as being the potential source of the right to grant compensation in circumstances in which there was a statutory prohibition which prevented you from doing anything else. That case is exactly on all fours with the current case. There is a statutory prohibition against one of the remedies for which Lord Keynes's Act provides, viz. The grant of an injunction. There is no statutory prohibition against the other remedies for which Lord Keynes's Act provides, viz. Compensation for past breach and future breach. Therefore, there is no reason why the court should not exercise its power to award those categories of compensation. And no good reason at all has been put forward by the states for suggesting that there is a good policy reason for not allowing compensation where there has been a wrong and there has been unconscionable conduct, because their entire argument is, as I've said, semantic. They said you don't have jurisdiction in relation to remedy A, ergo you don't have jurisdiction in relation to the other remedies which are conditional upon the right to obtaining remedy A. And my point is that there are various alternative remedies for which Lord Keynes' Act provides. If one of those remedies is outlawed by judge-made rule or statute, then that doesn't affect the other remedies that are available. I wasn't proposing to repeat the point in relation to whether it's right to say that there wasn't jurisdiction because of the possibility of the state consenting. It's a rather peculiar idea, I have to say, in the context of a case such as this one, that a contract between an insurer and a ship-owning member would contain a clause in which consent was given to waive state immunity, which is what appears to be contemplated. But obviously the facts of this case are peculiar because of the fact that the claimant who claims pursuant to the conditional benefit doctrine is a state. But the idea that, in a sense, the answer to this question is that, oh well, states can always consent to waive state immunity, and you have contracts quite often in which such waivers are contained, it is, with great respect, a rather far-fetched one. So, my lord, that is, I would submit, the correct understanding of Jagged and Sawyer and Lord Bingham's statements. Can I then just go briefly to Fury against LaRue and this question of what jurisdiction means? And you'll recall that I dealt with this pretty briefly in opening, but you have the relevant paragraphs in our skeleton, so I'm not going to take a great amount of time on the point. The point is that jurisdiction in the strict sense connotes jurisdiction over the defendant, whether personal jurisdiction or jurisdiction pursuant to service out under the CPR. That's adjudicative jurisdiction. My learned friend, Miss Hart, has made the point that the State Immunity Act and injunctive relief are enforcement jurisdictions, he says. Well, actually, I do take issue with that. The remedy of an injunction is an adjudicatory remedy. What you are actually seeking, just as much as damages is an adjudicatory remedy, what you are seeking is a remedy which will be adjudicated on in an action involving the state.
The distinction between adjudicative and enforcement jurisdiction was reinforced by the Supreme Court earlier this year in this very context in the Argentum decision, Argentum and Republic of South Africa.
Yes.
And in paragraphs 36 and 37, Lord Lloyd-Jones makes it very clear that Section 13 is enforcement jurisdiction, which I think is what Lord Diplock said in Alcom.
It is what Lord Diplock said in Alcom, and I do recall, my lord, that's the South African bullion case, the Argentum case. My point is simply this, that Section 13, when one is talking about the enforcement of injunctive relief, is an enforcement remedy, and Section 13 in the remainder of it is clearly looking to coercive remedies against states, which is enforcement. But when you're looking just at the question of whether or not there is a power to grant a particular remedy by way of injunction, as opposed to the remedy for a failure to comply with that remedy, and obviously the point with injunctions is, as has already been made, is that injunctive relief is backed up by coercive sanctions. And so to that extent, it's clear that that is a fundamentally enforcement-based consideration. But the grant of an injunction for breach of an equitable obligation is actually simply the grant of a particular form of relief by way of remedy for that breach, in the same way as the grant of compensation is a remedy for that breach. When it comes to enforce your right to compensation, well, again, that's an enforcement jurisdiction. And I quite accept that. But my lady, my point was simply that it's not quite that simple, with great respect, where you're asking what remedy is available at the adjudicative stage. And here, actually, we are asking what remedy is available at the adjudicative stage, because essentially, tested like this, going back to Justice Falk's question, well, at the moment that the claim form is issued, that actually is clearly part of the adjudicative stage, I would respectfully submit. Then actually the question is, what type of applications can the court entertain? And the answer that is given by the states is, well, what you can't do is you can't apply for a particular form of relief. And the court has my point that actually, yes, you can apply for the particular form of relief. It may well be that the court has to say you can't have it. That's not a jurisdictional bar, that's simply a rule which means that you will inevitably lose. In the same way that if you issued a claim for an injunction in relation to a state within the European Union, whilst we were still within the European Union, that would be bound to have failed. And that wasn't a judge-made limitation, that was a limitation which the European Court laid down, which was binding on us by reason of the European Communities Act. So, yes, and it was an interpretation, as I'm reminded, of the Brussels regulation, which was a statutory regulation as part of English law, not a judge-made limitation at all. So if we go back to where we began with all of this, then if the court asks itself, well, did it have jurisdiction over Spain? Answer, yes. What remedies did it have jurisdiction to grant? The State Immunity Act says it doesn't actually have the power, have the jurisdiction to hear an application, entertain an application and hear an application. It would have to, absent consent, it would have to say as a matter of English law you can't get an injunction against the state. But that would not mean, in my respectful submission, that the English court couldn't say, but because you can't get an injunction against the state, you can have damages instead to compensate you for the fact that we can't give you an injunction. The wrong has still been committed. You're still entitled to be put into the position that you would have been in had the wrong not been committed. We can't put you into that position by the grant of injunctive relief, but we can put you into that position by the grant of compensatory relief, and we should and will do so. Now, can I just then briefly go back to my Lord Master of the Rolls point? And this is a point that your Lordship raised with me yesterday, which is the interrelationship between the equitable compensation claim and the equitable damages claim. So I know that your Lordship is troubled by and interested in that point. And as I hope I made clear yesterday, then my submission on that is that pragmatically, it doesn't actually matter which route the court takes, whether it is equitable damages or equitable compensation. What I would say is it can't be neither. If the position is that there isn't a right to equitable damages, that fortifies the need for a claim for equitable compensation. And if there isn't a claim for equitable compensation, that fortifies the need for equitable damages, because otherwise, then a party that has been wronged has no remedy in respect of that wrong. And that is, with great respect, not actually a situation that this court should be prepared to countenance. It is exactly the situation which all of the tribunals to date have refused to countenance. Sir Peter Gross gave both types of damages. Dame Elizabeth gave equitable compensation and then said, I don't need to give equitable damages because I've given equitable compensation. And the judge's view was, if you get equitable compensation, which you should because of the fact that you won't get compensated in any other way, then actually there is all the less need for the alternative remedy, and he found, for the reasons that he stated, that there wasn't that alternative remedy. But it was clear that in his mind, then, as long as you got your compensation in one way or another, then justice had been done, which is, after all, what equity is all about.
There was a lot of discussion during the debate about equitable compensation about the circumstances in which it should be awarded, effectively discretionary elements. You've indicated that, I think, that quantum, there would be no difference between equitable damages and equitable compensation as regards quantum. Would you make the same point about the issues we were debating about the circumstances in which the court should make a mandatory award?
I would, yes. Again, actually, there are two issues really that, and they're the same two issues that I sought to identify in answer to your ladyship's question yesterday. The one is that the wrong is the same, and so if your ladyship is thinking about, for example, a territorial question.
No, you've made your submissions. You don't need to repeat them.
No, well, and I would simply say that exactly the same considerations apply under the heading of equitable damages as apply under the heading of equitable compensation, if that answers my lady's question.
It does. Thank you.
Thank you, Ladyship, pardon. I'm just checking to see whether there's anything else that I need to say. Probably a point I've really made already, but just to make sure that I have. Mr. Thompson makes the point rightly that the cases that we have been looking at with the could-would type distinction none of those are cases where one's looking at a statutory bar. This case is really all about the construction of the statutes read together, as I've said. These cases that we've looked at, or the Chancery cases that we've looked at with the could against would type situations, they're all actually, in one sense, binary situations. As the cases that Lord Justice Millett, as he then was referred to, Lavery and Purcell and the like, were cases where there was either impossibility or, put another way, no unconscionability about the conduct of the relevant party. So the position was that at the time the application was made to the court, then the damage had been done. Nothing could be done to undo the damage. And so that is not this case. Things can be done to undo the damage in this case, and should be done to undo the damage in this case. Can I make one very last point? And this is, in a sense, go right back to the beginning of this debate, and that is which part of Section 48 of the Arbitration Act we are concerned with. So Section 48(5) deals with the grant of injunctive relief or specific performance, and says that the arbitrator is to be in the same position as a court in relation to those powers. And you've had Mr. Thompson's submissions on that, and he will no doubt be replying briefly, or not replying briefly, he tells me, on those points. The point I was seeking to make is the order actually that the arbitrators were being asked to make in these arbitrations was a monetary award. And that's Section 48(4) of the Arbitration Act 1996, not Section 48(5). So it's only because of this sort of elastic reasoning that the states have adopted, whereby they start from the fact that the relief is injunctive relief. They then say the arbitrator's power is only the same as the court in relation to injunctive relief, and you only have the right to monetary relief if you have the power to injunctive relief, or to grant injunctive relief, that we get to the argument about these alternative parts of Lord Cairns's Act, which are there actually in order to cater for a situation in which you don't get an injunction. Or, to be quite honest, to cater for the situation either where you do get an injunction but you suffered loss over and above the amount of loss that will be catered for by the grant of an injunction. That's in addition to past loss, which will not be prevented by the grant of an injunction, or in place of, which is future loss, which would be prevented by the grant of an injunction, but which will not be prevented because the court has decided not to grant that injunction. So it's even a more fundamental point, if you like, than that, because it may be, and I would submit it is the case, that the state's starting point is the wrong starting point. My lord, my ladies, unless I can be of any further assistance to the court, those are my submissions on this
And
point.
the human rights appeal starts with Miss Webb at 2 o'clock, does it?
The human rights start points with me,
With you?
my lord, and starts at 2 o'clock, and I'm aiming to be finished well within the day, certainly by the end of the day. And I'm certainly aiming, even if I don't finish within the day, only to, pardon the phrase, dribble into tomorrow.
So we should finish, what, by lunchtime tomorrow?
We should finish by lunchtime tomorrow, I would hope.
Marvellous. Okay, 2 o'clock.
Court rise to table.